you've heard that my background was in civil rights law, but it was actually reconnecting with Luis and learning about his experiences with Tuesday that got me passionate about this issue and got me inspired to do this conference. And actually shortly after reconnecting, I witnessed an incident of discrimination, much like ones that folks with service animals experience on a daily basis. And it was just so shocking and appalling to me because although the animals provide such valuable emotional support, it's also a lightning rod for discrimination and confrontations on a regular basis, which to me is obviously counterproductive and outrageous and something that we need to work together to address. Before I get into the meat of it though, I do want to say a special thank you to Golden Gate, my alma mater. I did the public interest specialization here, which I feel prepared me very well for what I'm doing, and as you can see, they're still supporting my endeavors, so thank you. And my gorgeous slides were produced by my husband at the wee hours of the morning, so thank you to him. Okay. So basically, this is a rapidly evolving area of the law. It's almost like a moving target. There's a bunch of different statutes that apply depending on where you are physically, what state you're in, if you're in your home, if you're out in public, what kind of building it is. There's been recent changes in the law. And there's case law that sort of defines it on case-by-case basis. So I'm going to do my best to give you a cogent overview of what is out there. I have prepared a written document. You can pick one up. It looks like this. You can pick it up at the registration table, and we'll have links to it online. It's more detailed than my slides, so don't feel like you need to copy down everything in my slides. And it actually has legal citations for practitioners. Okay, so basically, there's, as I mentioned, there's different statutes that apply in different situations, and a number of the disability rights statutes provide for reasonable accommodations in general, but pretty much the big or only federal law where service animals is actually explicitly defined is in the Americans with Disabilities Act. And there was recent revisions to it in March of this year, which have major implications, which I'll get into. Basically, so this is the current definition. Let me just read it for you. Any dog individually trained to do work or perform tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or mental disability. So the difference here, previously, the definition was a lot more broad, so there's pros and cons. This is great because it actually explicitly provides protections for, I'll just say psych service animals, but it also narrows it. So there's different species of support animals that and service animals that people have wonderful benefits from. There was a lot of controversy around the exclusion of monkeys, for example, because they have been able to provide service for quadriplegics, like with physical, tasks as well as emotional support. But the debate centers around their capacity to transmit diseases and potentially become violent. That's what is alleged. So that's no longer included. It's not that there's no protections, it's just the ADA does not expressly protect them. Similarly with birds, reptiles. And then also, this is an important distinction, emotional support animals. So the key difference here is the training to perform a task to the benefit of a person with a disability, recognizing the situation and responding to it. So emotional support animals can also be invaluable and therapeutic for companionship and non-judgmental positive reinforcement, affection, just being life-affirming in general. But unfortunately, they are not protected under the ADA. So examples of the kinds of tasks, well, Luis already shared that dogs can retrieve medicine, intervene in stressful situations. There's just a whole host of tasks, and it's very individual to the person or the partner of the animal. Not sure if I said this on here, but the definition is also now limited to dogs. There's a slight exception for miniature horses, and there's some, because some people have allergies to dogs, but there's limits to those protections. So again, it's more narrow. So I thought a sort of easier way to wrap your brain around the statutory scheme would be to break it down by where you are in a place to see what protections you may or may not be afforded. So when you're in a public accommodation, such as hotels, restaurants, theaters, gyms, basically anything that's privately owned but open to the public, and also when you're in a government or state like service or building, or a university that's receiving federal funding, or public schools, libraries, or so forth, you are protected under, well, public accommodations is ADA Title 3, and the state and local government is Title 2. So this is what is protected, as we just talked about, service dogs, including psych service dogs, and they're allowed wherever people are allowed. So they're not subject to the same restrictions that pets would be, because they're not pets. They're working, for the benefit of the person with a disability. And so they get full rating where the individual would. We covered the species. Okay, there's the federal laws, and then there's state-specific protections, and it completely varies from state to state. As Luis mentioned, California has some broader protections. Basically, the states have to, at the minimum, provide the protections that the federal laws do, but they can also give additional protections. And I was actually at a panel a forum a couple of weeks ago with Dr. Morris in the city of San Francisco, who is currently considering what kind of protections to extend and getting feedback from the community. So keep your ears open for that, because the city is very interested in hearing the needs of the community and what further protections may be required. So one of the exceptions in California is that if the dog is actually currently in training, they are still protected under the laws, whereas under the ADA, it has to be a fully trained animal to receive the protections. Okay, so let's say you're out and about and you're getting discriminated against, which unfortunately happens on a regular basis. A proprietor of a facility or service can only ask you 2 questions. They can't ask you what your disability is. And this is really important for people with what's considered invisible disabilities. You can look at an individual and not know what is going on inside them, and it's, frankly, none of your business. And that's why some of the controversy arises about whether or not the dogs need to wear the cape to identify them, and the law does not require it, although as a practical matter, as you can hear, even when they are wearing it, you're often discriminated against. So it's almost really like necessary, not, as I said, as a practical matter. Anyways, what can be asked is whether or not the animal is required because of a disability and what work or task the animal performs. Once that's been established, you are entitled into the public accommodation or government facility. You don't have to do any further analysis about whether or not it's a reasonable accommodation, because the ADA has already established that it is. So you have carte blanche access. Again, documentation is not required, but as a practical matter, it's an awfully good idea to have it with you, because inevitably you will run into these problems. You can't be charged a surcharge if you're, for example, in a hotel where guests with pets have to pay an extra fee, because again, this is not your pet. The only situation in which the animal can be excluded is if it's out of control, or posing a direct threat or if it's not, housebroken, which I think is reasonable. So the defenses that a public accommodation may raise, which could potentially be accepted, is that making a modification to accommodate the service animals would fundamentally alter the nature of their goods, services, facilities, privileges, advantages. This is actually a fairly high standard. There was a case that I had read where there was a brewery and an individual with a service dog wanted to take the tour, and they said, oh, we're providing food or beverage and this is unsanitary, and basically the court said, that's not the case, and there's definitely places along the tour that that the animal can go that has no impact, and so you can't just kind of waive that excuse and have it accepted. So more California specific protections, just talk about the dogs in training. There's actually criminal penalties for violating the rights of a person with their service dog, or injuring the service dog, or, God forbid, killing the service animal. There's also penalties if you misrepresent that your animal is a service animal and they really are just your pet, which I think is important to protect the rights of people who really do have legitimate service animals. ID tags are available through the county animal control, but again, this is totally irregular. Different ones provide different looking ones, different ones. They're not supposed to require a test. There's just supposed to be an affidavit that said that you know your responsibilities and that you're not misrepresenting. Some of them require you to take a test. Some of them have tags that look super official, and some of them have tags that look like they came from Petco or something, like some machine. So, there needs to be some unification. I'm definitely on board with what Louise is saying. Next area would be the workplace. So employment is covered under the ADA, but it's a separate title. It's Title I. And in Title I, there's no express right the way there is in the public accommodations and state facilities, but you can request a reasonable accommodation. The advantage to them not using the same definition that's listed in Title III is that if as a reasonable accommodation, you do need an emotional support animal or a species other than a dog, that request has to be considered and get through. If they meet these standards, it has to be granted. So basically the query is, does the animal provide a service versus just being for comfort? And is it necessary for you to perform the essential functions of your job? In this case, more probing questions can be asked than if you're out and about at a public accommodation. They can ask why it's needed, whether it's trained, proof of training. Basically, they can determine whether or not it's going to disrupt the workplace. By the same token, they're not your doctors, and they're not in a position of deciding what's best for you medically. So even if they think that it might be better for you to have a different accommodation and they would rather not have a dog or other animal, that's not really their prerogative. And also sometimes the documentation that they would need to accept would be less formal, because for what Louise was explaining, these certifications are not available, and it may not necessarily be prescribed by a doctor even though it's necessary for an individual. Again, they can raise the undue hardship. However, merely having an animal in a workplace doesn't constitute hardship. So it's very case-specific inquiry, which is why the ADA, the defined areas are so nice, because it's not case-specific. Again, you just have the carte blanche rights. So in the housing situation, hope I haven't lost you guys yet. As you can see, it's really like across the board, all different laws here. The relevant laws, which my colleague later will be speaking in detail about, is the Fair Housing Act. There's also Section 504 of the Rehabilitation Act, and then the California Fair Employment and Housing Act, although in this case, the California protections are fairly consistent with the federal protections, which frankly are pretty broad. And when these changes were made to the ADA, there was actually a memo that was issued through Housing and Urban Development that made it very clear that they're not adopting the ADA definitions. And in a housing situation, they are very open to the reasonable accommodations of animals that are not officially service animals or that are other species. And the rationale is that you're in your own home and you're not subjecting other people to it. This is your own prerogative in your own home. And there's also very personal things that happen in your home that people really need the support of their animals for. So, as I said, there's not a clear definition. Again, it's just that reasonable accommodation analysis. And they still need to provide the disability-related benefit to an individual with a disability. They have to be necessary to afford the individual equal opportunities. And this is an important key phrase, and it pops up in some of the other statutes. The fact is that this is not a special benefit. This is an equal opportunity. It's, you have this assistance to kind of make you on equal footing with other people that don't require this assistance, and so that you can be a fully, actualized contributing member of society. So the disability must be related to why you have the service that the animal provides must be related to your disability. And again, you can't be charged a deposit for your animal the way you would if it was a pet. But if they do damage beyond regular wear and tear, that is your responsibility. The housing provider doesn't have to assume that risk or responsibility. Again, the same kind of defense is about the financial burden, fundamentally altering the program. Again, we'll hear more in detail about this from the specific case that Mr. Levin has litigated. So I won't dwell on that. But basically, and then also if there's a direct threat or substantial damage is going to occur. Then finally, in the air travel context, there's a whole different law that applies, which is the Air Carrier Access Act. What is allowed is emotional support animals, so that's nice, it's broader, and psych service animals. What's excluded, for sure, is snakes, reptiles, ferrets, rodents, and spiders. And the way that it's written is kind of ridiculous. It's like animals like this, but it doesn't explain what they mean by animals like that. It's kind of one of the, you recognize it when you see it, like the pornography analysis. And then there's animals like miniature horses and pigs that might be allowed in situations like if they're not going to cause disruptions and if they're not too big and if there's room for them, and as long as those things are met, then you have to allow them. And then there's the dogs that definitely are protected. So it's dicey at best. And as a practical matter, it's good to try and prearrange these things before you get to the airport and try and board your plane with your companion. They are allowed to ask whether the animal is a service animal. They can, again, ask what tasks they perform and make sure it's for the benefit of the passenger. And then they get different documentation. They are required, or they can require a note that's signed by a licensed mental health professional within the past year attesting to the need for the psych service animal. I believe if it's a guide dog, this is a different situation, like for visual impairment. As you can see, different kinds of disabilities are treated differently. And there is sort of a general acceptance of, guide dogs for visual impairment, although I'm sure individuals with guide dogs also run into challenges, but there's the whole, these other hurdles when it comes to these invisible disabilities. If the airline does decide to deny you, they are required to give you a written explanation why, and if they don't give it to you on the spot, you are entitled to it within 10 days. So finally, where do we go from here? If you are discriminated against, you have some options. Frankly, none of them are 100% awesome or perfect. You can file a complaint with the Department of Justice or Department of Fair Employment and Housing in California. There's different time restrictions depending on if it's a government entity, you have 180 days. If it's another accommodation that's not a government entity, you have longer, but as a practical matter, you don't want to wait that long. You could file a federal or a state lawsuit, but again, this is stressful and time consuming. Not that I want to take business away from my peers and myself, but again, I would definitely advocate other steps before that. There's an ADA information line that is also on my resource page and up here that you can call. Unfortunately, they keep East Coast business hours, so, and on Thursdays, that's reduced hours. So if you're on the West Coast and you're being discriminated against in the evening, you're kind of out of luck. But if you are able to reach them, they can give you important technical assistance, and you could even try to put them on the phone with the proprietor and, have them straighten things out. You can try and educate the person, but, some people seem pretty steadfast in remaining ignorant. Luis was making reference to New York. I read a case where this woman was alleging 34 different instances of discrimination against the Public Transit Authority in New York, even though she had printed out their express brochure stating her rights. And they dragged their feet so long that then the union said you can't still go after our employees, although she still was able to proceed with her federal case. There was another case where somebody decided to call the police to have them advocate for their rights, and the police ended up arresting the person with the service animal and escorting, yes, it's shocking and appalling, and her case was thrown out. She filed suit against the police and the case was dismissed. So this is not to say that all police are ignorant of the law, and in some cases, they really will advocate for your rights, but there's a lot of confusion about the law. Again, it's so much variance in the states and who can enforce what, so that's a challenge. You can go home and write a letter, and then here is a sample letter that Dr. Morris wrote, which actually, I guess within 24 hours, she got a response from the manager, right, and this was at a Lucky store where she was discriminated against. But again, if you're in an emotionally vulnerable situation and feeling triggered by this altercation, you might not feel empowered to go home and write a letter right away. Although if it's successful, it can be a very empowering experience. But I also feel very strongly that our whole community needs to work together to address this problem, and especially as disability rights advocates. If we see these instances, we need to speak up. We need to educate each other, have these kind of seminars, talk amongst ourselves, and if we work together, the wheels of justice can turn just a little more quickly. So, thank you very much for your time.